next session that's going to be focusing on an important aspect that's looking at cross-border insolvency framework. And yes, for the session, we are delighted to have once again amongst us for the session, Shardul Shroff, Executive Chairman, Shardul Amarchand Mangaldas Corporation. Welcome, Shardul sir. Shardul sir, as we all know, he is widely recognized as a pioneer in the field of corporate law. He has participated in training and drafting of several important economic legislations and company law reforms in the country. And he was a member of the Insolvency Law Committee constituted by the Government of India. He was also a member of the committee constituted to review decriminalization of offenses under the Companies Act and the Committee on Cross-Border Insolvency. He's been consistently rated as a leading lawyer by several international forums and publications. He is the recipient of National Law Day Award from the President of India Practice at International Standards. Welcome, sir. And leading the session is indeed a very interesting panel of panelists. We are delighted to have amongst us Ashish Chhawchharia, Partner and Head Restructuring Services, Grant Thomson Bharat. Ashish is an FCA as well as an insolvency professional. He has a vast and good and wonderful knowledge of the insolvency regime and stressed asset resolution strategies with expertise in turnaround services, financial operational restructuring. He's also a member of Insol International and Insol India, and he is a part of several chairs for various chamber committees on stressed assets. Welcome, sir. We are delighted to have amongst us Bahram and Vakil, co-founder AZB and Partners. Bahram and Vakil is India's foremost infrastructure and project financing attorney. He has been acknowledged as a leading project finance lawyer by most international publications for over a decade. Some key practice areas include infrastructure and project finance, banking and finance, mergers and acquisition, joint ventures, general corporate, and private equity. He has been recognized for his expertise by an array of international publications. Welcome, sir. We're delighted to have amongst us for the session Mr. James H.M. Sprayregen, partner, Kirkland and Ellis LLP. Mr. James is the founder of the organization worldwide and building the group from inception in 1990 to become the premier restructuring group in the world, described as a legend in the bankruptcy space and one of the United States' most sought-after bankruptcy attorneys with extensive experience representing major United States and international companies in restructurings. Welcome, sir. And yes, we are delighted to have amongst us Joanne Collett, partner Walkers, who represents clients in relation to contentious and non-contentious matters, including commercial disputes, complex cross-border restructuring, contentious valuation issues. She also represents debtors, creditors, shareholders, investors, insolvency practitioners in a wide range of litigation, insolvency, restructuring related matters. Welcome. So on that note, once again, a warm welcome to our very distinguished moderator, as well as distinguished panelists for the session. And without further ado, let's brainstorm into the very important segment happening here at Legal Era's 7th Annual Insolvency and Bankruptcy Summit 2022, and we deliberate on cross-border insolvency framework. Once again, warm welcome to everyone. Over to our moderator and our distinguished panelists. Mr. Shroff, please. Mr. Shardul Shroff, please. And yes, we can see that Mr. Shroff is there. So once again, a very good afternoon, sir. Welcome to Legal Era 7th Annual Insolvency and Bankruptcy Summit. We began the day with a very significant opening remarks by Mr. Shroff, wherein he pointed out in a very pragmatic and rational way to understand the IBC code in a deeper manner. So once again, sir, we are delighted to have you once again back with us for the cross-border insolvency framework. I welcome Mr. Shroff and I request, sir, to take the proceedings on from here. Mr. Shroff, please.
Something.
That's good.
We can hear you now.
It's
working. Yeah, thank you so much. So I just want to reiterate what I said in the beginning, that I'm extremely apologetic to all four of you on the panel. There was a farewell function at the firm, and I just couldn't avoid not going. A very dear colleague of ours is sort of starting out on her own, and I had to be there. So please pardon me. Having said that, I thank all four of you for having agreed to participate in today's session on cross-border insolvency and the kind of issues that one would anticipate in the course of establishing this as a new law and a new procedure for India. I'm going to start with Joanne and then request James to supplement or add to whatever Joanne covers. And then I will go down to Bahram and Ashish because of their enormous experience on cross-border and their having pioneered the first Indian case of jet airways or jet wings. I'm sorry, I'm confusing. So let me start with you, Joanne. In your experience as a practitioner in cross-border insolvency, what will the purpose by enacting provisions of the cross-border insolvency model law into our Indian legislation achieve? What do you think will be the purpose served by introducing this law?
Sure. Hi. Thank you for having me. Look, I think I've got relatively unique experience. I've been practicing insolvency law for about 22 years. I'll give away my age now. But I've practiced in Australia, in New York, and then through to the Cayman Islands. I'm now located in Hong Kong, doing BVI, Bermuda, and Cayman Islands law. So as part of that career, I think in terms of why would you need to deal with cross-border insolvency, I think the basic answer for me is that every case that we do involves some sort of cross-border element. Now that might be a feature in part because of how the offshore world works. So for example, the reason I'm in Hong Kong is that 74% of the main board of Hong Kong listed companies are actually one of BVI, Bermuda or Cayman, primarily Cayman and Bermuda. But I think, when we're dealing with these structures, we always see, an offshore company up the top, and then we might have a BVI company, we might have some Hong Kong companies, and then down through into the mainland where the operating assets will be. And so in terms of why you would need it, for me, it's sort of the bread and butter in terms of how these groups work. There are lots of benefits to having a structure whereby you have different legal entities in different jurisdictions. It might be that you can comply more easily with local regulations. There will obviously be separate legal personality and issues on ring fencing liabilities, for example, and assets. It's also possible, we see a lot of consolidated group accounts here, so there's no sort of burden in case of accounting. So in terms of why you would do it, for me, it really just increases certainty. If we look at why the model law, the Untitled model law was enacted in the first place, now that was 25 years ago. I think, we're looking really, it starts with a case called HIH back in 2002. And, looking at, insolvencies going on in that case in Australia and also in the UK. And, there were assets in the UK, but, the question was whether those assets should be remitted back to Australia or, whether they should be protecting the local creditors in the UK. I actually worked on that case. And the court really thought about, well, how do we protect sort of local creditors, but also thinking about the fact that we've got a company that's operating in various jurisdictions, and this idea of effectively modified universalism, where it sort of makes sense that you would have one bankruptcy proceeding wherever it may be, and have everybody sort of put their proofs of debt in and share in the assets of the company equally. The flip side of that, of course, is the local protectionism and the idea that, if assets are in a particular place, then they should be available for local creditors. So there is always a tension there in terms of how a bankruptcy should work when you have cross-border and assets in multiple jurisdictions. But I mean, that is the purpose and function really of enacting the model law, is to effectively have a scenario where you have one bankruptcy proceeding and everybody effectively is bound by that proceeding.
Thank you, Joanne.
Whether or not that works, whether or not it happens, given we've got model law countries and non-model law countries currently, but that would be sort of the purpose and function of having those provisions.
James, let me turn to you now. In the context of the UNCITRAL model law, which is, as Joanne just mentioned, 25 years vintage, that law really deals with a single corporate debtor, a single company, and insolvency in relation to that single corporate debtor. It does not envisage group enterprise. It does not, bring in within its fold the subsidiary structures, nor does it bring into consideration the joint venture related concerns that would arise. So in your view, do you think this particular model law needs to be revised at this phase? Because 25 years is a long time, and to introduce a vintage law when the world has moved on to a more modern law might be regressive. But what's your view?
Well, thank you for having me on this panel. I'm pleased to talk with all of you and the audience. I think on that question, we talk about 25 years and it sounds like a long time. I actually commented to one of the writers of the model law, Jenny Clift, that it had taken this many years to have only about 30-ish countries adopt the model law. And her reaction was, well, lots of other model laws have taken 50, 75 years to get enacted. So she was actually very pleased with the number of countries that had adopted the model law thus far. So I guess there's a perspective issue. As to the corporate group point, I think it would be best over time if the model law was adjusted or amended to take into account corporate groups, because as you say, the world has moved on, and most cross-border bankruptcies involve not just an entity, but a whole group of entities with affiliates and subsidiaries. And we have figured out what I'll call workarounds and ways to muddle through with the corporate groups and the use of the current model law. So it's not as if it's a disaster or that it doesn't work, but it would be much better in the world of best practices if we were to update the model law. Just in the way the world works, it will take a while to get that done.
Thank you so much, James. Bahram, what I would like to ask you is something in relation to your experience as the counsel to JET Airways, to the RP in the RP's counsel in Jetways. We have Ashish, who was the resolution professional in that case. But I would like to ask you first, Bahram, as to what were the hurdles, both judicial or otherwise, in reaching the protocols with the Dutch administrator. And if you could share some of your experiences, that will be great. Thank you, Bahram.
Thank you. Thank you so much, Shardul, and thank you to all my fellow panelists and all of you for joining in. So in the interest of time, I'll just say that at the outset, it was a very happy experience. I hope Ashish, at least on this issue, will agree with me. Otherwise, it's been very, very long drawn out, and he has done all the heavy lifting. But on this issue, given that the law is silent, the IBC, I mean our domestic law, and unfortunately, we don't have the cross-border in place, it was entirely a cooperative effect. And for that reason, the NCLT, in my personal view, with all due respect, took a very technical, narrow reading. And fortunately for us, the appellate tribunal took a broader, more practical view of life and allowed us to go ahead with the protocol. As you say, which was, a kind of best faith, sensible approach where both the Dutch administration and on our side, we had mutual respect, and it went quite smoothly. I mean, I'd be very interested, of course, to hear Ashish's perspective. But if correct me if I'm wrong, Ashish, I think it took about 4 to 6 weeks, in spite of the fact that we had to go up to the appellate level. And there was a lot of mutual respect from both sides. And therefore, I think we got a lot done given the circumstances and lack of specific legalese.
Thank you so much, Bahram. Let me now turn to Ashish. As I mentioned, Ashish is a very experienced resolution professional practicing in India, and he has been the leader of the pack in relation to cross-border insolvency, the first to really get a resolution on the JET case. Ashish, I wanted to ask you that with your experience in the context of creating a protocol for the insolvency-related practitioner kind of protocol that you need in order to smoothly run the cross-border concurrent processes involved. In your experience, do you feel that such processes or protocols need a little more experience, a little more knowledge in terms of negotiating, a little more legal skills? And should there be a process where the Committee of Creditors has a panel or a board which really participates in this negotiation? Or should the Committee of Creditors appoint their own legal counsel for this task? Your view.
Thank you, Shardul, and thank you, Bahram, for the kind words initially. And very good afternoon to all the fellow panelists and the audience here. I think the experience of the first cross-border protocol, cooperation protocol that we had in JET has actually taught us a lot of things. In fact, I'm hopeful that I've shared a lot of that experience with the committee which was formed for considering the cross-border framework for India. But let me tell you, it didn't all start very smoothly. I mean, as Bahram mentioned, it was contentious to start with. The NCLT had not taken recognition that there is actually an issue there. There are some assets of the company lying overseas, and the insolvency or liquidation of that entity or that business had already commenced a few weeks before the Indian process started. So, but from there to achieve what we did achieve, this protocol, which, was about coordination, cooperation, sharing of information, we achieved that in probably, 6 to 8 weeks time. And it was quite a record in doing that. And I think what was important is that both myself as the Indian administrator and the Dutch administrator respected each other's authority and respected each other's laws. We recognized that we needed to work together. And with that spirit of cooperation, when we got down to, working on making the protocol, things were a bit easier. I wouldn't say it was all smooth. Of course, it required immense support from, legal advisors, both in India as well as a legal counsel who we had engaged in Netherlands itself. What was really missing, and why could it, and can it happen every time? In theory, yes, but practically, I can tell you the amount of time and effort this took. I mean, 6 weeks sounds less, but it can stretch to much longer. And in that period, what happens to the assets? Who will manage and maintain those assets for the best interest of the creditors? Who has the superior position in this? What's the COMI? There's so many issues which need to be addressed in all of this, and then comes the access to the each other's records. The Committee of Creditors, or here as we call it, the Committee of Creditors here. It would be great if we can have some kind of a framework that would help at least lay down the baseline, and from there you have to build upon it, because I think no two cases are alike. No two cases are similar. Every case is different. But if we have a basic framework, and which is what I think is one is trying to achieve through this model law, and I know that the committee has proposed that we should adopt this, cross-border unsettled model law with some amendments, of course. That will help, I think, the entire insolvency ecosystem in India. And because not every time maybe we'll be able to achieve this outcome, because I think a lot of credit goes to the administrator there, who was very cooperative as well. And what if he's not? What if his interests are different? His or her interests are different. So, and what if there's a debtors in possession versus creditors in possession regime? There may be different regimes followed. So, if there is some guidance and framework, I think that would achieve much better outcome. But all in all, yes, I think, with Bahram's advice and, our Dutch council advice, we did achieve a good outcome here.
Thank you so much, Ashish, for sharing your experience. Let me get back to Joanne. I understand that you were actively involved in the Lehman Brothers insolvency process. And despite, correct me if I'm wrong, again, the model law was the one in place for the particular transaction, but you got yourself working around issues of the corporate debtors, subsidiaries, and associates. So if you could share that experience with us as to how that process happened, despite group enterprises not being legislated upon.
Yeah, look, I think, and that was obviously quite a number of years ago now, in terms of how effective the Untitled model law. I might ask James to maybe address that one as well. I'm sure he's probably got more experience than me with it. But, I think when we think about the model law and how it's currently drafted and been adopted by most of the countries that have adopted it, one of the examples that strikes me is the Lehman Brothers case. So we were working for the Committee of Unsecured Creditors in that case. And I remember being in court and we were acting in relation to the top company. So LBHI was the acronym. And before the Chapter 11 filing had been made, and in the usual way, the cash had been swept down to the English subsidiary. And I remember, sitting there and the judge in New York saying, well, give the money back, and talking to the administrators who had been appointed in the UK. And the UK administrators basically saying, well, we've got to comply with our own obligations. We're a completely separate proceeding, and we're governed by our laws in England. So, I'm sorry, judge in New York, but we're not able to do that. And it just was, for me, a really stark reminder that when we're dealing with, modern company structures and groups, it may be the case that although practitioners perhaps want to be able to have a group solution and work with protocols and things like that, they are somewhat constrained by, the legal system in which they find themselves and their duties and obligations in their respective jurisdictions. So for me, that's sort of a good example of perhaps a deficiency in the current model law as in the one that's been adopted. But I should note that there is an amendment or an update to the model law, which is kind of coming through now. It's interesting that it's interesting timing. The English legislature is looking at adopting the new provisions for the model law now. And those provisions will effectively deal with or try to deal with the idea of these corporate groups and how we deal with them by basically trying to find a group insolvency solution, and sort of setting out this idea of a planning proceeding whereby, you're looking at, again, a group insolvency solution. So it'll be really interesting to see, how much traction those amendments get. I think they came out in about 2019, but perhaps with where we are in the global pandemic situation, I don't think people have maybe been focusing on cross-border insolvency in that time. But the English court's looking at it now, and I think it'll be really interesting to see who else adopts that, because I do think it's quite an important development in terms of how the model law works. But James, I was going to say, I might see if you've got any views on how the model law works as well. I think you've probably seen it more than I have.
Yeah, no, I thought those are good observations. I mean, you use Lehman Brothers as an example, and that was a ways back now, but it's not a poster child for the model law working well cross-border. There was a lot of disputes, and I'm actually taking this panel from London, as a matter of fact, and I think there could have been a lot more cooperation amongst both practitioners and judiciary across borders. But having said that, I actually think generally, there's growing pains, but generally it's worked pretty well. One of the reasons, for example, Lehman Brothers is such a bad example, is because it was an unplanned emergency filing. The best ones of these are when you can have the right amount of time where the practitioners can organize across the borders and do things collectively and in a thoughtful, sequential manner, as distinct from just falling into a proceeding. So it's not perfect, but it's a vast improvement over not having the model law, I would say.
James, let me sort of now ask a further question to you. Because this is a new law, whenever it happens, and I'm told that it's likely to happen in the next parliamentary session, what would you really advise the government or to the practitioners in this particular place in India on the global coordination that would be needed or the harmonization of insolvency proceedings, and to deal with the kind of complexity India is facing, because we are a very litigious country and almost every decision of the tribunal has a potential of being challenged in the appellate court. So if the processes have to synchronize, and if a joint forum of judges or judiciary has to go ahead with the process of cross-border insolvency, do you see any scope of actually overcoming the domestic delay processes because of litigants really disrupting the process time and again? Is there any suggestion that you can have so that the concurrent process really works smoothly?
Yeah, well, I'm not a miracle worker, but I think that as I mentioned earlier, if the more sort of planning and coordination and cooperation that can occur across borders amongst the practitioners, I think the better it would be. Now, each situation is bespoke, and it depends how much time you have and how much, not just the practitioners, but how much the principals are willing on various sides of the table are willing to cooperate to make things more smoothly. There's all sorts of formal protocols and guidelines and things that have been developed to smooth the cross-border process. And I think those are all valuable. I have found that the sort of more de facto and informal cooperation and communication across the borders is what really makes it work. And practitioners actually getting to know each other around the world. So when these cases happen, there's sort of what I'll call a trust factor and an ability to work together and a reservoir of goodwill, I think is incredibly important also. And I would say the same thing for the judiciary. Obviously, each country has its own legal process that needs to be respected. And so if folks are going to litigate in India on whatever they have the right to litigate on, you're not going to be able to stop that. But I have seen, like, I'm a former president of INSOL, and INSOL has this thing we call the judicial colloquium, where we bring judges together from around the world, where they have an opportunity to interact and discuss best practices and communication and cross-border issues. And I found over the years that that's been very valuable to the judges to be able to actually meet without the practitioners there. And when cases have come, it's actually helped their formal and informal communication. So I think all of these, there's not a one size fits all or one silver bullet, but all of these various things are what kind of come together to help smooth the functioning of a cross-border case.
James, one more supplemental question to you. In India, we have almost 20 national company law tribunals, or perhaps even more, which deal with subjects of insolvency domestically, corporate insolvency. Now, on the question of protocol, especially judicial protocol, would you feel that it is better to have a guideline structure, as Ashish also mentioned, in the context of the insolvency protocol? Similarly, a judicial protocol as to what would be the fundamentals between members of the judiciary across territories to agree upon as a process, as a concurrent hearing happening, or for that matter, the exchange of documentation, and all that would go in terms of judicial management of the insolvency. Is that something which should be done? Is it recommended, or it will happen on the go? What, in your perspective, would help India to really give credence to the cross-border insolvency regime that they're about to initiate?
Yeah, I would probably call it more having standards, I think would be a good thing. And developing those so that they exist and people and judges and practitioners get familiar with those. The reason I call it standards is I caution against getting too prescriptive for any particular case. So I think those could be standards or guidelines, but there needs to be some flexibility in each particular situation, because every time we think we've thought of everything, a new case brings different issues and something different that we all have to deal with. So I don't think it would be good to have things rigidly set in stone as to how things need to be handled, but sets of standards and guidelines, I think, would be very valuable.
And James, in your experience, does a standard like this exist in the world? I mean, you know much more than any one of us on this panel as to whether such a standard is available for discussion by the legislature or by the drafting committee in India, because that would certainly help in furthering the cause.
Yeah, there's a lot of international standards that have been developed and that are available for study. They would need to be contoured and massaged so that they fit within India's system. But I think there's a lot of learning and work that has been done internationally that I think could be of great use to the judiciary and practitioners in India. I'm always sensitive to every country's got their own, not just legal, but social and cultural and political issues, and those all will need to be taken into account in using what's available that's been developed internationally already and making it so it's useful and applicable to India's system.
Thank you, James. Let me now turn back to Bahram. Bahram, having heard both James and Joanne on issues in relation to how practically things would work and what needs to be done at India's end in relation to creating that environment in India, if we are witnessing and or noticing what's happening in Singapore, which has effectively developed the best practices and become the jurisdiction of choice in relation to arbitration, and is now aspiring to become the jurisdiction of choice in relation to restructuring and cross-border insolvency by virtue of how that court is manned. So in relation to the SICC as a process, they have brought in international judges with experience in insolvency and globally who have practiced globally, and therefore are better equipped than what we would see in a national company law tribunal. If we are competing for this kind of work, besides, of course, the Comey principles and all the principles that are applicable in which jurisdiction will get the main proceeding. Do you feel that for the purpose of competency and for the purposes of developing special knowledge in cross-border insolvency, we should also create a special tribunal of experienced global judges?
Thanks a lot, Shardul. And I have to say, your questions have really been spot on and very timely. I was really happy to hear from Joanne that UK is looking at this the group part closely, because as Ashish mentioned, it's I think too dangerous to work and continue to hope for goodwill and cooperation. So having something in place will be very useful. I'm also cautioned by the fact that the godfather of IBC and the draftsman of the first of our model law, I think almost 4 years ago, Mr. Vishwanathan is there listening to us. So I have to be really careful in what I say. But I think, just very quickly, given the time constraints, a fun fact about Lehman in India, which I think James will enjoy hearing, is that we hid behind the fact that the rupee doesn't float freely. And as you say, each country kind of did what was in its best interest. And around midnight, Shardul will know this, the godfather of banking in India, a gentleman called Deepak Parekh, called all the key bankers in India into a room and said, guys, we can't deal with all this cross-border stuff. We do a domestic offset, and then we just send the balance out. So all the Indian banks were in a very happy shape. So that's how we dealt with Lehman here. And we did have the benefit of FEMA to help us. So sorry, that's just a fun aside. But Shardul, to your point, a very, very important question. In fact, Mr. Vishwanathan, I'm really glad he's here, because our finance minister then, who was really the architect and the wind behind IBC, Mr. Jaitley, he had said that from day one, we should have a specialized tribunal, specialized judges who will have this necessary expertise. And that was the idea in phase 2. And surely we are now in phase 2. And Shardul, as you know better than anyone, the regular corporate work is suffering tremendously at the NCLT level. So yes, just like Singapore has led the way in arbitration and done such a fantastic job, I think we should certainly seize on this. And it's high time we had a specialized tribunal. And given that you all are in Delhi, I would request you to please push for it strongly.
I wish we had that authority to push it. Ashish, getting back to you again, the issue, in a sense, of dealing with questions of misfeasance, malfeasance, forensic investigation, issues of tracing of assets, in the Indian context itself is a vexed question and a tough one. When you look at issues in terms of cross-border insolvency and issues in relation to diversion of funds, siphoning of funds, round-tripping of funds, and all those kind of issues that are practical realities of today, do you believe that those kind of powers should be embedded in our legal system? Because for an ordinary litigant or even a foreign administrator to go and get those orders from the civil courts would be extremely difficult. It may be even difficult in the context of the existing IBC, because that is meant in relation to domestic insolvency. So in your view, as a recommendation, would it be advisable to introduce this as part of the process while we are adopting the model code? Is that something you would recommend from the perspective of what's happening on the ground in India?
Thank you, Shardul. I mean, certainly, in my view, having some enabling, facilitating provisions would be helpful. But I think largely, if we are able to, adopt a cross-border insolvency framework, that itself would, help in achieving the outcomes that we desire. We have seen in our experience, it's not very uncommon that funds have been found to find its place outside India, where borrowers are in India, banks are in India, but funds have gone and created assets in various jurisdictions outside India. Not having a framework here to be able to go after those funds directly does impair our abilities to some extent, and vice versa to that extent. I mean, yes, we have we can go out and seek recognition and then appoint local lawyers or local insolvency professionals to assist. But to be able to do it directly would certainly, I think, help in terms of time as well as cost, rationalization in this process. And I think there's a lot that the Indian financial system can gain out of this, because based on some work done by our firm, we have seen this tremendous opportunity there. I mean, to give you an example, recently, there was an old case which was, taken up, and we identified almost $1 billion of Indian banks which have found its way outside through layers of companies, and a worldwide freezing order was obtained, and now there is effort being made to kind of recover it for the Indian stakeholders. So all this is happening, without currently having the framework or the legal ability to do so directly. But if that's available, certainly I think it's going to speeden up the process. That would be my view.
Joanne, let me also ask that question of you, because there are 3-4 constraints that I want to explain and then take your reaction. Under our Code of Civil Procedure, you have to have a notified reciprocating territory for really observing or giving recognition to the judgments and decrees of foreign courts. There are grounds already incorporated in our Code of Civil Procedure on what basis the Indian court would recognize or refuse to recognize a foreign judgment. And one of the grounds is public interest, where it manifestly differs in terms of the public interest applicable in India. Let me give an example in the context of insolvency law. We have a very special provision, which is popularly known as Section 29A, where there is a whole list of persons identified who cannot participate in resolution, nor can they buy into the assets of a liquidating entity. The objective being that when this law was introduced, there was a moral question for the government at that point of time. It was one of the biggest insolvencies happening at that point of time. And a lot of the funds which were lost were of the public sector banks. And therefore, there was a fear factor in the government that are we giving away something which is very valuable at a throwaway price to the same persons who caused that problem. Now, this is a unique issue as far as India goes, but it is not necessarily a law outside of India. As I understand it, there is no resistance in the US jurisdiction of letting the promoter bid for his own company and work out a reduction of debt and a resolution of debt. Therefore, the question of public interest assumes very much center stage in India. Now, the formulation of the model code as far as India goes proceeds on the basis that a tribunal has the right to refuse the process on grounds of manifest public law being in discord. My question now is that In the field of arbitration, it is post-award. The test of public interest is not an upfront test. It is a test after the foreign decree or foreign judgment has been granted. In the case of model law, it is something which is done at the initiation of the process. It is done during the process, and that is therefore a decision prior to even dealing with resolution or even dealing with insolvency as such. The important question is, should such a power at all rest with the tribunal, or should it be a matter of state policy? Because to displace the applicability of law, to displace the principle that we are saying that this model law is not going to be followed, should such a power be vesting in a tribunal at all, or should it be a matter of state policy and a declared state policy, so you don't have an unruly horse deciding on what is public policy? That's a question I pose to Joanne and to James, and I'd like to hear Bahram also in the Indian context. If Mr. Vishwanathan wants to take a crack at it, I'd be happy to ask him last because he's hearing us. So Joanne, I would ask you for your views in terms of, do you feel this is an appropriate measure at all, which should rest with the appropriate authority in India, namely the National Company Law Tribunal?
Well, look, I think it's sort of immediate reaction to that is, you know, the public policy of a particular jurisdiction, I think, should be set effectively by that jurisdiction. Now, within India, whether that's a particular tribunal or the courts, or whether that's an executive function, I suppose is really a matter for you. But you know, I don't think that the model law, for example, is trying to set a policy direction. I think what it's doing is setting up a framework whereby where you have a company that's insolvent, there is a framework or a mechanism by which a foreign representative appointed elsewhere, you know, can come into India and seek assistance by way of recognition. How that happens in terms of whether centre of main interest and whether you get non-main or main recognition is sort of part of it, but not sort of the main thrust of it. So look, I think in terms of recognition of judgments, I think that's a slightly different question. You know, we have, for example, in the offshore world, there's similar restrictions in relation to taking a foreign judgment, money or non-money judgment, into each of the Cayman Islands, BVI or Bermuda, and asking the court to effectively recognise that. Now, we have different statutory ways of achieving that, or alternatively, common law. The common law, of course, is quite robust and derives from English law. And so I think when we talk about enforcement of judgments, even in sort of the common law or the offshore world that I'm dealing with, there is always that limiter. There is always, you know, the requirements of enforcement of a judgment, but also there's the overlying shroud of public policy or public interest, and namely that the enforcement of the judgment should not be against it. Now, the way that we handle it in the offshore world is that that's determined by the courts, as opposed to some sort of government arm. But you know, my view is that there should be a limiter. There should be a public policy exception. As I say, in my experience, it works very well from our perspective to have those determinations made by the courts. I hope that's answered the question.
Thank you, Joe. I just want to clarify two things before James starts his answer. In our model law as adopted in the draft that has been in circulation since 2018, there is an exception for public policy. That's not my worry or concern. My worry, which I'm articulating before you, is that the decision on whether it is manifestly contrary to public policy results in a stoppage of the process of cross-border insolvency. Unlike in the case of a foreign judgment, where it happens after the decree. Because here it's a continuum of process and there it is a completion of process. You're asked to really enforce a judgment in the ordinary common law civil sense of civil jurisdiction after the judgment has been rendered by an international court. Here, though we have framed the entire model law in terms of amended it or modified it in terms of what should be applicable in India, the concern that is there is, should an appropriate authority like NCLT have the jurisdiction to say, I'm not going to adopt this procedure because it is manifestly contrary to public policy or public interest. So that's why I mentioned the fact that Section 29A is a public policy in India. Interest given to interim financiers in the course of revival of a company is a subject which is different from what happens globally. So if any resolution plan or any international system of insolvency violates these two provisions, there could be a situation where the tribunal may say, no, we are not going to follow this cross-border principle. Therefore, my concern, and which is what I'm asking, is that should such a power at all vest in a tribunal to suspend the applicability of law? Should there be a specific definition of public policy? It can't be an unruly horse, especially since it applies fundamentally to the jurisdiction of cross-border insolvency. And therefore, should there be a change which we should implement before this law comes into being? That's my question to you, James.
Yeah, so I think you summarized the public policy points very well. You know, I would have the view that this public policy exception, we need to make sure it doesn't sort of swallow the rule. And if it's used too broadly and too often, it will diminish the value of enacting the model law in the first place. So I think of it as kind of like a relief valve. Some countries use the word manifestly, the US does, and other countries leave out the word manifestly, which is would be a broader exception because manifestly sounds pretty extreme. I know in the US, we've had hundreds of what we call Chapter 15 cases. I think we've only had 3 or 4 decisions saying something was manifestly against public policy. And that's why I agree that I think it would be best to leave it to the judiciary and to leave it undefined. Because I think if you start trying to define what public policy is, I don't know where you stop, because that can encompass, incredible numbers of things. And each case may have different implications for public policy. You might have there was a large mortgage case that involved hundreds of individuals that had put down money for homes to be built. You can see there might be public policy implications to something like that. But I think you want to be careful about importing what I might call alleged public policy issues too broadly, because that would diminish the value of the law.
James, just one more supplement, which I request you to add to that question. Should the power be left to the National Company Law Tribunal, or should there be a higher judicial authority, or even a declared state policy? And I'm asking this with a specific reason, that there are too many tribunals in India to really come and conclusively say that this is manifest public policy and there is uniformity or universality of how this would be applied in the Indian context. That is the question I want to request you to address. I accept all what you have said. Should the matter be left to a tribunal, which is not a court in that sense? It is a quasi-judicial forum. It has a judicial member and a technical member, and they are not globally trained to address this question of public interest. So I accept the fact that you don't want to define public policy, But I am equally worried by the fact that you don't want 29 interpretations of issues of public policy. There has to be some framework with the power to create the exception outside it, and that's my request for you to address.
Yeah, I might be getting outside the bounds of my expertise with exactly how the Indian system works, but I would assume there would be rights to appeal, and I would think of that as the kind of protection on it, because we have the same problem in the U.S. We have literally hundreds of bankruptcy judges, and you could end up with different interpretations. But some of these things have gone up to our higher level appellate courts and gotten clarified, and I think that's a good system. This is really a proxy for sovereignty when you talk about public policy, and countries don't want other countries to impose their rules on their and impinge on their sovereignty. So I think it really is an incredibly important relief valve. It just should not, as I said, swallow the entire statute.
Thank you so much, James. Bahram, I would request you for your views, considering that you are a practitioner of Indian law, and what do you feel are the likely dangers of such an aspect embedded in the model code? Do you see a potential for abuse, knowing how Indian practitioners are creative and how they tend to bring in stuff which was never envisaged when drafting the law?
No, thanks a lot. I understand perfectly from where you're coming, James. I think the same exception in our arbitration statute has created a lot of delay. So I think that it's a poor record. And that is why Shardul is worried. And then added to that, of course, the two key issues that it has a more drastic effect. It comes at a much earlier point of time, and it is decided by tribunals. But I think it may be very valuable to have Mr. Viswanathan's view. He has already curved it as much as possible by adding the word manifestly. So, as James said, we have followed the US model where we have tried to keep it as narrow as possible. Shardul, you totally understand that the way the architecture goes, I don't know if we can get out of the tribunal issue. And the Supreme Court is not going to be happy with us if we say that this issue must be taken directly by it, because they're going to say, we have our plate pretty full. Again, something you will be more aware of than me. So I don't see an easy solution. I think basically it's going to be case law and the normal solution, because it's an important issue. But I just don't see. If there's more language that you can add to narrow it further, might certainly be worth looking at. But the architecture part, I think it's too late. But sir, I don't know if you feel that there is some other solution, Mr. Viswanathan.
So thank you so much, Bahram. Viswanathan, sir, let me sort of point out where I am worried. If a tribunal takes the view that this is manifestly public policy, the way the structure is framed, they can oust cross-border insolvency. So though there is an enacted law embedded in the Indian statute, and the government accepts and legislature also accepts the inclusion of a model policy into India, the concern is that a tribunal can negate the law. Normally, that is a function of the judiciary, whereas here, this is a quasi-judicial tribunal. Normally, in a civil procedure action, it happens post-judgment. Here, it is in the midst of the proceeding, and that's the concern. So if you could address this issue, do we need to raise this concern, number one? Number two, do we need to address it? Because this is a possibility in India. It's not, I don't see it's not likely, but it's a distinct possibility, because of the way practitioners in India are creative.
Thank you, Shardul. In fact, I'm glad I joined this session. I was aware of this problem when I gave this draft on cross-border insolvency to Mr. Arun Jaitley. Bahram knows that. At that point of time, your concerns are very right. At that point of time, we are only concerned about how to give a bill which is acceptable to the parliamentarians, because they were always asking where is the need for cross-border insolvency when we tried to go with this proposal for a long time. It has been delayed. So we wanted, if you don't have this clause, it will be very difficult to convince our parliamentarians and that why are you giving up, as if we are throwing away an advantage. That's okay. But I take your point very much. And when I drafted, I had this butterflies in the stomach sensation. Our Bahram knows that. So I settled for borrowing it from Arbitration Act because I battled with the arbitration for 20 years in the law ministry at the saw pipes case, and we came up with this compromise. And I am not very comfortable with this formulation either, but your concern is very much. I am not for arming this NCLT tribunal with this power to decide on public interest. It will lead to chaos. We need to have some way or some other authority to decide on this. We have to think of something. I'm glad you raised this issue because this will be a very bugbear. And this will lead to a lot of complications later as we experience in arbitration. In arbitration, I had a personal experience because I was in the government throughout. So I think maybe we can think of some other authority, a single authority who can deal with that. I think if that is a good idea. Mr. James and Joanne, they are not aware of the state of the Indian tribunals, or very independent judges have independent thinking, and they each will not agree with the other. So we need to, with our very energetic lawyers, they will come from one forum to another forum and will create chaos. So I think this is an important issue. I think we have to head on. We have to take this issue right now. We have to have this class. There's no two questions on that. You also agree on that. But who will decide on that? We have to be very clear, and we have to be with our very bad experience with the Arbitration Act. We have to be very careful here, because otherwise it will lead to chaos.
I'm glad, sir, that you equally, endorse the fact that this is a problem area which India has to deal before its model law comes out. And I'm
because
sure
I could not see of any other way of dealing with this issue, so I borrowed simply from Arbitration Act and left it at there. So this is something I have to be handled.
And I think, sir, the reason why I'm concerned is, having seen 6 years of the working of the IBC and how the tribunals have, looked at it. I would not be too surprised if a maverick member of the tribunal goes ahead and says, cross-border insolvency is not applicable, or I am ousting that jurisdiction, which is a disaster for India.
Yes.
So this is a serious issue as far as India goes, and I'm glad that the international experience or their understanding from similar jurisdictions or similar law will now be sort of given adequate weight in the context of how we should model this modification before the law comes into place. The regulator, IBPI, is listening in to these sessions, and clearly, so this is something which we can document and forward to them, that we did discuss this issue, and this is our recommendation. So thank you so much, sir.
I don't know if it helps on that point, and just sort of echoing something James said before, but at least in my world, and it sounds similar to James' experience, the public policy exception is always going to be very narrow. We in terms of litigation say that if you're starting to rely on a public policy argument, you might have problems with your case. Those are not common arguments to make, and keeping that narrow, whoever makes that decision. But I would have thought to uphold the point of having the model law in the first place, whoever makes that decision, keeping it narrow is probably going to be the key there.
No, I can see, for example, how the position will come for India. I can see it coming from a foreign jurisdiction into India, where the local tribunal is asked to decide contrary to Section 29A. And this will become a big issue between the promoters who have a limited space in the Indian context and the aspect of not having a similar disability in a global context. So this is, in my view, a live issue as far as I am concerned, and we have to tackle it, because if it's going to have the effect of displacing cross-border insolvency, then we have achieved nothing. So that's where I'm coming from, and I'm glad Mr. Vishwanathan has seen this problem before, and at least we can think of some solution, because this is not just about an international perspective. I think there are peculiar facts in India, which is because it's a different insolvency law. It limits the promoters, and that's why my concern. I would request each one of you, if there is something which any of you would like to add to the questions that have been pointed out by me, and we can then debate it shortly for about 5 minutes, because time is nearly up. Any question? Yeah, please.
Yeah, I
Please.
would just add that I applaud what you're trying to do in India, and I applaud enacting the model cross-border law. I would just say, don't beat yourself up too much, because whatever you do it's not going to be perfect, and it's going to need to develop with the cases over time, and there'll be bumps in the road, and that's not a reason not to do it. And I guess it's the old don't let perfect be the enemy of the good. And we've amended our bankruptcy code hundreds of times since we enacted it in 1978. Then you never get it exactly right, and even when you do, things change, and you got to change it again. So I think you're moving forward, and I would keep doing it.
Thank you so much, James. Anything, Joanne, if you can add, please?
Yeah, look, I think that's a really great way of putting it, James, and I completely agree with you. Frankly, selfishly, from our perspective, we're living in a global world. We do have these cases that are restructuring cases where we can go and use the model law for, recognition of compromises and things, and we've been doing that regularly, in the last, say, 5 years. But, going forward, if we do get back in a scenario where we're seeing a lot more, complex cross-border insolvencies, fraud, where we do need to be doing asset tracing. In some jurisdictions, it's, even though they may not have the model law, there's you can use recognition and comity to achieve that outcome. But at the end of the day, I think having the model law in place is really beneficial, because it gives everybody the rules of the road. So that if you need to come to India to seek assistance, there is a way of doing that, and it gets a foreign practitioner in a bankruptcy case to be able to get access to the courts, to be able to get orders for turnover, to be able to get all of the things that you might need if we're acting for liquidators cross-border. So the model law, I think, is a good way of doing it. The offshore world hasn't enacted it. We've done it in a slightly different way, but with the same outcome. But I think the benefit of the model law here is that you do have 30 other countries who have already gone through this process and have, as James has said, gone through and made amendments, and there's lots of judgments. So there should be a lot of jurisprudence to help you, having enacted it, to work out how to actually implement it. But yeah, from my perspective, it would be really helpful for you guys to have that enacted. So yeah, thank you for having me today.
Anything, Bahram, in conclusion?
So thanks so much. As both James and Joanne have said, fingers crossed. It's one of the few things in IBC, otherwise we moved so fast. But as I mentioned, Mr. Vishwanathan had this ready, I think it's 17 or 18. So there's been a long delay on this. I really hope that it comes sooner than later. And thank you so much to everybody.
Thank you. Ashish, any suggestions in closing?
Yeah, the only words I would say that, as we are at the cusp of adopting the model law, or in whatever modified form it is. I think our regulator and the whole ecosystem, we need to take steps to educate and train our practitioners, the insolvency professional, lawyers, and in fact also the judges to be able to deal with these cases. Because and if we need to take assistance from international judges, international lawyers, and practitioners like James and And Joanne, I think with that experience of cross-border, that would really help our law. I think otherwise just enacting the law alone may not, yield the right results. Thank you.
So anything that you would like to add, Mr. Vishwanathan, sort of just to wind up?
My only wish is I've been battling for this cross-border insolvency right from the day when I gave the bill to Arun Jaitley from 2017. I wish it could be enacted quickly. We can sort out the other issues as we progress. I think it's been long delayed. We have to do it very quickly. That's my only wish list right now.
So thank you so much, sir, and thank you all for coming and participating and giving us your valuable knowledge and experience to this process. So thank you so much for this, and it's a pleasure.
Thank you.
Thank you.
Thank you. Thank you, everyone. What a wonderful session that was. Thank you. Thank you so much, sir.